Good afternoon again, everyone. I don't want you to stop eating. I want you to keep eating, please. That. You may be able to go back up in a second if you wish. I'm only going to speak briefly, but I do want to welcome everyone and thank you for coming. This is the second year we have held a jury appreciation lunch. And as the flyers on your tables indicate, we have a number of sponsors who helped to make this happen. And we appreciate their support. My brief remarks are taken from a book, Why Jury Duty Matters, by Andrew Ferguson, who details how important the jury really is to America. The right to be a juror is guaranteed to all eligible citizens. The right to trial by jury helped spark the American Revolution. It was quickly adopted at the Constitutional Convention and is the only right that appears in both the Constitution and the Bill of Rights, and also appears in the Declaration of Independence. But for many, a jury summons is an unwelcomed inconvenience. It all begins with an email or letter. Dear citizen. An invitation. Sure, it uses the word summons and is probably not the kind of invitation one looks forward to receiving, yet it is still an invitation to participate in the American experiment of self-government. Your community needs you. It's only polite, is it not, to accept, and it's even better to think about how you might enjoy the experience. It may well be the closest one ever comes to the Constitution, true for many. In a country formed from a single founding document, it is amazing how disconnected many of us are from its meaning and its purpose. Jury duty changes that reality for many. It is a day of constitutional connection. A jury summons is an invitation to participate. Jurors are asked to involve themselves in some of the most important and personal and perhaps sensational and sometimes terrifying events in a community. Participation teaches the skills required for democratic self-government. As a juror, you are asked to vote based on contested facts. You debate issues framed by the parties, and this involves listening to others and tolerating dissenting views, as well as expressing your own opinion. Throughout jury service, you are known by a number, a juror number, and whether you are a soccer mom or a senator or both, you are simply a number to the jury system. And the number is not meant to insult, but to equalize. You know your presidential vote counts as much as anyone else, but you also know that lobbyists, interest groups, and activists have more influence in the political process than your single vote. But in the jury room, those differences become irrelevant. Whether you are a rocket scientist or a rock guitarist, a linguist or a laborer, jurors are given the same facts, see the same witnesses, hear the same arguments, and get an equal voice in the decision. In short, jury service is an example of how democracy is supposed to work. Jury service connects people across class, national origin, religion, and race. It exists as one of the remaining connecting threads in our wonderfully diverse country. It links us to the founding principles and challenges us to live up to them. Congratulations to the jurors who are here today. We thank you all for the service you have completed with our court. Your service reflects our constitutional spirit. Please know your service is deeply appreciated by me and all my colleagues. You strengthen our constitutional character. You exemplify both the importance as well as the satisfaction of jury duty. Now it's my pleasure to introduce Kristen Beach, who helped organize this event this year, who's going to introduce our keynote speaker.
Welcome. Thank you again, everyone, for coming. So today's speaker is Judge Mark A. Drummond. He's a judicial advisor for the Civil Jury Project at the NYU School of Law and soon to be its director. He was a trial lawyer for 20 years, and he'll leave the trial bench this coming August. He's conducted written and oral surveys for every jury trial in which he's been involved, both as trial counsel and as trial judge. And he has written and trained on the most effective ways to present evidence to today's juror. He has trained United Nations War Crimes Tribunal prosecutors at The Hague and in Arusha, Tanzania. He's trained advocates for the U.S. Department of Justice, the Federated Bar Association of Japan, and the Beijing and Shanghai Arbitration Commissions. Excuse me. He has also trained advocates in Tokyo, Beijing, Shanghai, Tasmania, Tanzania, Vienna, Zurich, Frankfurt, the Inner Temple, the Middle Temple, New College, Oxford, Keble College, Oxford, Nottingham Law School, Scotland, Ireland, Kosovo, Macedonia, and the Navajo Nation. For years, he's been the program director for teacher training for the National Institute for Trial Advocacy in New York City, and he's the recipient of the Honorable Robert E. Keaton Faculty Award, also from NEDA. So please join me in welcoming Judge Mark Drummond.
Thank you, Chris. One of the jury innovations I'm going to talk about, which I believe Judge Zuhairi uses, is the timed jury trial. So I have set this at, I believe it's 12:44, because as soon as this goes off, I will tell you my 1-minute favorite jury trial story. I'm honored to be here. I absolutely love jury trials. I love jury trials on 3 different levels. I love them, one, as an advocate, trying cases in front of juries. Second, I love being a trial judge and trying jury cases. And third, I love the people who come in and spend the time with us. Could I have a show of hands? Who are our jurors who joined us today? Yes, let's give them a round of applause. I mean, as I tell juries all the time, you know, think about it. The day before, they were mowing lawns, washing dishes, paying bills, and they go out to the mailbox and there's this jury summons. And they have to come in and they have to sit with maybe 100 people they don't know, answer questions about themselves in front of all those people, and if picked, sit with 12 or 6 people and decide things that are crucial to somebody's fate, somebody's life. It is a very daunting and very onerous burden that we place on the jurors. I also tell them that, you know, when you think about it, we have a lot of rights in the United States. You know, we have the freedom of speech, we have freedom of the press, we have freedom to assemble. And really, when it comes down to it, we only have a couple of duties. The one duty is April 15th to pay our taxes. And the other duty, other than the duty to vote, although there are no consequences for not voting, is when you get the jury summons. And the reason I admire and respect jurors so much is because it is so easy to get off jury service. I mean, somebody, all they have to do is say, you know, I'm biased. I'm biased against this or biased against that. And we can tell, after being on the bench for 20 years, we can tell whether somebody is truly biased or is just making something up so they don't have to do this exercise. So that's why we so appreciate it. I want to go through, this speech is going to be structured like this. I'm going to talk about why I love juries as a jury trial lawyer, why I love them as a judge, and then I'm going to end up with addressing the jurors. So I want to kick this off. As Chris told you, I would do jury surveys after each one of my jury trials. And I became a much better attorney because of the jury surveys. And I brought a couple with me to show you. As an attorney, I would send these out, and I will tell you that you get more surveys back from cases you lose than cases you win. It's like, you've won, what more do you want from us? We're not filling out the survey. This actually was from a case which I lost. I know you can't read the first question, so I'll read it to you. I asked, what did you like best about the jury trial experience? This juror wrote, very interesting. Second question is, what did you like least about the jury trial experience? Sort of boring. This question, further comments. I feel that with all of your evidence, you had a very strong case clear up until the end. The verdict was hard to come to. Now, perhaps I should not have delivered my closing argument in that case. And this is my #1 favorite juror response from a case. As a trial lawyer, what did I do best during the jury trial? You were very polite, looked neat, and brought out many small points in the defendant's favor. Well, Clyde, I'm sorry you're going to prison for 5 years, but at least they thought I looked neat. So I would send these out, and I now, as a judge, send out the jury surveys. I learned so much from the jurors themselves. It just wasn't a one-way conversation with the jurors. I was, unfortunately, a checker when I first started trying cases. I would walk out and I would have this large 14-inch legal pad which proved that I was a trial lawyer. And I would stand in front of witnesses, and do I have a juror at this table? A juror at this table? State your name. And what do you do for a living?
I'm a speech pathologist.
How many years?
Many.
And that is how I would conduct both my direct and cross-examinations until a bailiff pulled me aside and said, Mark, do you know why the second row of the jury is smiling and the one woman has her hand over her mouth? I said, no. And she said, because the first row of the jurors who have their hands underneath the rail and you can't see them are all going like this. And you check things. And it was even worse during cross-examination, because when I didn't get an answer I wanted, and I didn't check it off, they'd look at each other and go, oh, he didn't get that one. So I learned from the juries as a trial lawyer, and it made me a better trial lawyer. As a judge, I will tell you that there is no decision in the courthouse that has a greater impact than a jury's decision. I mean, we judges make decisions all the time, but you never hear, what did the judge decide in the coffee shop? All you hear in the coffee shop talk is, what did the jury do in this or that case? I was just out in New York on the Civil Jury Project, and I was showing decision trees that these companies have come up with to try to sell to trial attorneys to make the decision as to whether settle or go to trial. And at the end of every decision tree is a list of jury verdicts from high to low. Everything works backwards from the jury's verdict. Everyone in the courthouse is interested in how the jury decides cases. And they are so sharp. I had a case just last year. It was an intersection collision case. We in Illinois allow the jurors to ask questions during the civil jury trial. They write them down. We judges sort them out with the attorneys, and we ask the question. So here was the case. 2 cars side by side. Both could turn left. In this lane was the plaintiff. In this lane was an 89-year-old woman who got confused. She wanted to go straight. She needed to turn left. So the 2 cars went like this. Now I'm thinking that this is a pretty low speed impact. You know, they're both stopped, they take off, they go like this. Oh no. Here was the plaintiff's testimony. I was in this lane, there was nobody in this lane. I started to make my turn, and she, in paren, the 89-year-old lady, tried to, quote, beat the light. And she T-boned, and at this point he hits his hand, and the jurors who aren't watching all jump like this. She T-boned me. Her car went over the top of my car, and that was the accident. I mean, it was like a Dukes of Hazzard type thing. Even though both cars were drivable, they drove over to the bank parking lot, exchanged insurance information, he went and got a pizza. So, after he testifies and is crossed, I turn to the jurors, I say, any questions? 9 hands went up. Most questions I've ever had. You know what the number 1 question was? Anybody? Where'd he go get pizza? What kind of pizza? What? Did the airbags go off? Now, you know, I know the attorneys in the room are thinking, well, I might have objected to that because you can't necessarily infer force from the airbags going off or not going off. But since he explained in such graphic detail that it was a T-bone accident, and although I might have sustained it on force, would have admitted on damages because he was claiming a closed head injury, and the airbag going off may have contributed to that. I let it in. Of course, the airbag didn't go off. Here was the verdict. The plaintiff's attorney asked for an astronomical amount. The defense attorney suggested a reasonable amount based upon the evidence in the case. And the verdict was under what the defense attorney even said it should be. Now that sends a message. That sends a message by 12 of his fellow citizens as to how much that case is worth. The final thing I'll tell you is we had a judge that went exclusively from bench trials to, the reverse, jury trials to bench trials. I said, how do you like it? He goes, I hate it. I love jury trials. I love to see how the attorneys try to persuade the jurors, and I love to see what the jurors come up with. And now, since we can look into your minds, see what the juror questions are. And finally, I want to talk about you and the jury system. You are on the leading edge of what started back in, I believe, 1215, or I think, Judge, you have 1016 or 1066 in your slides.
Long time ago.
Yeah, with the Magna Carta, when King John accepted the terms of the Magna Carta. However, that jury system would be unrecognizable to us today, because juries back then were people selected who knew the most about the case, the neighbors, most about the dispute. Now we've gone 180 degrees, and we want to have the people who know the least about the case. So they are true, impartial jurors. I also want you to know that you are not only on the leading edge of the juries in the United States, but you're also on the leading edge of what is a jury reform going throughout the world. In 2008, I went over to Japan because the Japanese citizens decided that they wanted to get involved in the decisions of guilt or innocence.
Ignore this.
So I will shorten this up. I will tell you this. I want to show you one video, and then I'll tell you the story. So we conducted a jury trial in front of 100 of both advocates and judges. And then we said, please ask us questions. And so they wrote all the questions down, and we were just flabbergasted by the number one question. We thought there'd be questions like, why 6 jurors? Why 12 jurors? Why peremptory challenges? Why the amount of peremptory challenges? No, their number one question was, why does the judge have to stand up when the jury comes in? And they wanted to make sure that they got the custom and the ritual correct. So we explained to them, that is the honor and that is the respect we show the jurors. That they are the ultimate arbiters as to credibility, as to the truth, as to the verdict in the case. We consider them to be equal to the judge, and that is why whenever the jurors come into a courtroom, everyone stands up, including the judge. I want to touch on a little bit what the Civil Jury Project is doing. We can't claim credit for this video, but I think you'll all be amused by it, because a lot of the jury innovations that we're trying to adopt, juror questions, mini closing arguments, pre-instructions, relate to what you're about to see. So let me get out of the PowerPoint and come down here and see if we can get this fired up. And what this is, come on. The premise of this is, what if we conducted college classes in the same way as we conduct jury trials?
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it. And you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can't take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on another important aspect of the course. Now, I won't be telling you what is important in this course, or what the rules are for the final exam, until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
I wish I could say I wrote that. I did not. My final pitch is you have the civil jury project cards on your table. If you as jurors, you who are the jurors, or anybody who served a jury will log on, we have a jury survey. We would love to have your feedback on your jury service. And finally, I will end with one of my favorite stories about a jury trial. I have a colleague of mine, her name is Jean Jordan. She was a judge in Indiana, and after retiring from the bench, she wanted to get back in the courtroom, so she volunteered at the state's attorney's office. And she tried cases for them, and she had this one case where she had an FBI agent. And the FBI agent was on assignment, going overseas, needed to get out to the airport on a plane. And unfortunately, she was in front of a judge who had a constitutional inability to not ask questions after every witness. It was kind of like if you've seen the movie The Verdict, Paul Newman, where he says to the judge, "Your Honor, I don't care if you try my case for me, just don't lose it." Every witness, he would answer questions, ask questions. So she said to the other attorney, "Would you go up and join in a motion that he not ask any questions, or this FBI agent's not going to make the flight?" And the other attorney said, "Well, I'll walk up there with you, but you've got to do the asking." And so, "Your Honor, may we approach?" They approached. She said, "Your Honor, we have an FBI agent. He needs to be on a flight. He's on assignment. This is a short direct, very short cross, no more than 15 minutes, and we would respectfully request that the court make no inquiry after we're finished. And the judge said, step back. And they stepped back, and he turned to the jury and said, I have been a judge in this courthouse for 17 years. And this is the first time that two attorneys have ever asked to approach the bench to ask that I ask absolutely no questions after the next witness. And you could cut the tension with a knife until a juror in the second row said, sustained. It's been a pleasure. Thank you very much.
Thank you very much for traveling here, for speaking. We'll have a little give and take now. By the way, what you just saw, I'm pleased to report to you, is not what happens in federal court. We have made a lot of strides since I tried my first case there many years ago. And I think it's fair to say, given the questionnaires we received from jurors after their trial experience, we do a lot to make their experience a positive one. And I want to acknowledge and thank the people from the courthouse who are here who help with jury service. Annie, Tina, Jen, stand up. Laura, anybody else from our clerk's office, stand up so we can acknowledge you, because they certainly do a lot. Again.
I'm sorry. That's not here.
So the jurors that are here, I'd like to kick a little discussion off, something recently that I learned that was kind of interesting, at least for me. How do jurors select a foreperson? And in a recent trial I had, I learned that they went in the room and they held a secret ballot. And the person with the most check marks was the foreperson. It was very civil, it was very quick. There was little oral discussion, but they didn't want to hurt feelings by starting it off with some sort of confrontation. And it worked very well. And the foreperson was very good, according to him, about allowing everyone the opportunity to speak and have their say. So let me just move around the table. I'll start over here at this table with Linda, who recently served on a trial. Can you share with us how the foreperson was selected?
Ours was pretty obvious. That was the person that.
Do we want a microphone for me to help with? Yeah.
When the room was really quiet and we weren't allowed to share or talk or, with it being very new to everybody, he was the one that kept asking questions and broke the ice with everybody, just, silly questions. And so we just kind of knew that he was kind of the person to take charge. And so.
And who led the discussion about who's going to be the foreperson? Somebody initiated by suggesting that person, or?
I think we just kind of all were in agreement that this person was a person who, talks, freely in front, he was an open speaker, and we knew he was kind of the person. So, and even before we made our decision, before we were able to talk, I asked him if he could kind of say a few words, in prayer, to help us all come to an agreement. And so he was the right person.
Let's pass the microphone to the next table, please.
Well, we all walked into the room and sat down, and this young girl said, I really want to be the foreman. And we all went.
We didn't want to hurt her feelings.
She was okay. She ended up functioning more as a secretary. Everyone had their say, but she just said she wanted it within 2 seconds of sitting down.
Well, the room was very silent. Nobody volunteered. So I volunteered somebody so that I wouldn't be chosen. And it went well.
So did you do it by just raising hands, or didn't even need to do that?
No.
Everybody said, yeah, fine.
Well, I was on that same jury, and I was really impressed by the fact that as I looked around the room and listened to conversations, I don't think there was anybody on our jury that wouldn't have made a four. Do you agree?
you know, I thought we had a really unique group of people who all gave and took. We really didn't have anybody who actually ran the deliberations. Somebody would say something and then somebody else would respond to it, and it just kept kind of going around and around, and it wasn't entirely, I mean, it wasn't highly structured with the four-person being in charge.
So you followed the directions, and every juror had an equal voice and an equal vote.
Ours was, it just kind of, somebody I think suggested that this one person, she kind of got nominated, I think she's a teacher. And there was 3 or 4 others that were more outspoken than the rest of us, but they just kind of went around and, do you think she'd be good? And that was it. She was excellent.
Do we have any other jurors here? Over there, we go.
Ours was nowhere near as scientific as the others. I think they had us file out of the courtroom in order, in juror number order, and file back in, and I happened to be number 1. And so they said, you're going to be the foreman. But I agree that I think everybody on our juror pool could have been the foreman. I think everybody would have done a great job.
So let me ask you an open question, then we can work the microphone back. Something about the experience that surprised you, either positive or negative, that you didn't expect before you began your service?
The one really overwhelming thing I had was that regardless of what decision we came up with, this was affecting somebody's life for the rest of their life, and not just them, their families, their friends, their peers, everything. So that really struck home with me. The other thing that I've even explained to a few people, I thought the judge did just an amazing job of explaining the process and the system and why we're doing this and why this took so long and why you're leaving the courtroom now and why you need to come back then and things like that. So I thought, yeah, it was a good process.
Yeah, that last point I think is well made. It's different from the video you saw. We do a lot more now as judges to explain to the jury what's going on, what their role is, and so forth.
That was created in 1998 and shown around to try to convince judges to do exactly what you say.
Judges sometimes aren't the first ones to realize they should be doing something different.
I had experience on a grand jury. That's my only time I've served. It was for a grand jury. But the overwhelming point from my service was negative, I have to say. Just one issue, that we were determining probable cause, and you have to have a consensus. And there was one for sure, maybe 2 people that it was getting late in the day and we couldn't get a consensus, and they were more or less saying, excuse me, you know, why can't we get on with this? And people's lives are affected, and it seemed just flippant. You know, their personal time was more important. And it reminded me from a movie, 12 Angry Men, that I love, and some of the situations they encountered there. But overall, the experience was wonderful, but that was one thing that kind of really took me back.
Thank you.
I think the experience that, you know, it was my first time ever being on a jury, so I had no preconceived ideas about, you know, how the things would go. But, you know, when you sit 12 people down and they all come at it from different perspectives and different points of view and all that sort of thing. And I think for me, we didn't have any really young people on our jury, but I was impressed by the fact that everybody was so respectful of everybody else that was in there. And to me, it just made the deliberation meaningful, I guess, if you can call it that. But it just felt like my concerns, everybody listened to and validated, and when somebody else had a concern, the validation was there from everybody else on the jury, and there was never, well, that's a stupid thing to think, or I mean, you didn't even get that impression.
Great.
I was pleased to serve on the jury. I felt it was a privilege, and it's an honor to be here. Everybody on the jury, again, we served on the same case, were very compliant. The thing I thought was rather funny was because we weren't supposed to talk about the case, we'd go back in the jury room and everybody would sit there, not say a word, and look down at their phones, or they were so reluctant to speak to one another, fearing that they would say the wrong thing or put the case in jeopardy. But overall, I was very happy to serve.
That's a current debate going on right now. There are some courts that are allowing jurors to discuss the case with certain instructions during the trial. I frankly have considered it myself, but that's sort of a hot topic right now, that restriction during the trial itself.
I think the thing that struck me the most was that after the trial, the judge came back and answered questions, and then we spoke to the attorneys as well. And one of the things he said was that when someone is charged with a crime, the full force of the United States government comes down on them. And you're just this one little person, and you have to defend yourself, and just how frightening that can really be. That's helpful.
And some of our jurors here were on civil cases and some were on criminal cases.
This was my first time serving, and I had an amazing experience. I think the process was awesome, and when we did get together and talk, the thing that I feared, because I'm a quiet person and don't usually speak up or speak on a microphone, I was in fear of the people who were very quiet, to make sure that, they had a voice, and and they did, and they spoke up when needed, and I think, and all 12 of us, had a voice and had our opinions, and I just think we all worked very well together.
Judge Helmuth, one of my colleagues came in, Jeff.
Late, apologies.
It's okay.
I had a hearing, and Judge Zuhuri can relate to this, scheduled at 10:30. It was supposed to be quick and just finished, so I apologize for not getting here sooner. There just wasn't a good way to break. But I thank you all so much for being here and sharing your stories with us. It's reaffirming about what we do in the process and the brilliance of the founders in terms of the right to jury trial, both in the Ohio Constitution and the U.S. Constitution. It always just to hear your comments and your descriptions, and even when there's adversity, it's just remarkable how you work through it. And one of the greatest things I've ever heard about juries is what I just heard, which is that at least on that jury, that any of you could have stepped into the role of foreperson, and your deliberations would have been effective, which is just remarkable in terms of the preconceptions people have about juries. So thank you for that.
Mark, do you have any questions you want to ask of the group, or any closing comments?
I am interested about the comment about discussions during. Judge Zuhari has an article in our most recent newsletter for the Civil Jury Project, and in that newsletter, it talks about one juror saying being allowed to do that lessened her anxiety. It's like you're sitting there and, what are these people thinking? What are they thinking? And the limiting instruction would be you can't decide the case, but you can discuss it. You can discuss, the evidence that just went on. The Civil Jury Project is trying to correct everything that you saw in that video. I just want to be clear about that. And it is amazing. I just had very quickly a medical malpractice case, 2 days of jury selection, 3 days of trial, settled after the third day of trial. Jurors came in. I said, I know you folks know something's going on because the big screen is down. And yes, they've settled the case, and I know that your first thought is, wow, what a waste of our time. 2 days of selection, 3 days of deliberations, and we don't get to decide the case. However, if you're willing to spend a few more minutes with us, we would love to debrief you. We would love to sit with you and ask you what you thought up to this point. We had 14 jurors, 2 alternates, 12 jurors sat with us for 2.5 hours. The courthouse was closing. Every half hour I would say, you folks can leave at any time, your jury service is done. They were fascinated by the process. We would have probably gone till 8 or 9 o'clock at night discussing the case. Many people are apprehensive after they get done with it. They absolutely love the system, and it doesn't work without all of you.
Do you think allowing jurors to discuss the case without discussing the verdict during the trial will shorten their deliberations at the end?
I think it will. I think it will, and even these jurors that, in my example that I just used, the plaintiff's attorneys went back for the debriefing. The defense attorneys who paid the money, they didn't want to get involved, and they left. And the plaintiff's attorney said, well, we were going to ask you for a verdict range within this range. Would you have returned that? And all the jurors said, well, we hadn't heard the other side of the case, but yeah, based upon what we heard, that would be within the ballpark of what we'd be looking at if we found a liability. So they all realized, hey, we hadn't heard the other side of the case. So I think they can discuss it. They can discuss, the witnesses without deciding the case. They follow the instructions, and if we instruct them, that will work. Yes.
I'll argue the contrary view, if you don't mind.
Sure.
And it's based upon last year's juror appreciation luncheon, where we also had some jurors participate. Very interesting comments, however, not the harmony that you may have experienced, relatively speaking, on your panel. And in both of those cases, when asked, there were 2 forepersons here, so a foreman and a forewoman, and both said, terrible idea, because they were dealing with factionalization and formation of opinions and pacts among jurors in the deliberation process. And for one juror, it was very, very problematic, so bad that she had to, Jack, was one of your cases, you remember, she at one point had to physically intervene between 2 jurors for fear that they were going to come to blows. Ordered a break. We're all taking a break, which is the right thing to do as forewoman in the case, and literally had to find a corner of the courthouse because she broke down and cried, thinking, I don't know if I can get through this. She did. She was successful. They might have reported at one point being hung, and you might have given them an Allen charge at one point. I don't remember all the details about the case. And interestingly, they both said things were so difficult in terms of sides that were chosen and getting people to break down those barriers, discuss, be open-minded, that they felt it would have been disastrous if they had had an opportunity to discuss it earlier, for fear that those alliances would form even earlier, before all the evidence, before the final instructions. Now that's just their experience with that jury in terms of what happened, but I found that it's not the response I expected. And it was interesting, and it was from 2 different juries, from the forepersons of those juries.
And we are, and I'm glad you said that, because we are looking at the different variables. Would jury deliberations throughout make a difference if the trial is a 1-day or a 2-day trial versus a 2-week or a 3-week trial? Does it make a difference whether it's a criminal trial where the prosecution goes first and the defense may have a legitimate reason to say, no, we don't want any deliberations? Or is this, and I believe you wrote about this in the article, letting the jurors decide whether they want to do it or not? Sometimes I'll say, folks, when do you want to start? When do you want to end? I always tell the jurors this, that my time, the attorneys work harder than I do. I know that because I was an attorney. And so I will come in on Sunday to help get the courtroom set up. I will work late at night over the noon hours to accommodate the attorney's schedule. But there is one group of people that I put over the attorneys, and that is the jurors. And nothing will upset me more than the jurors burning daylight, wasting time back in the jury room because we don't have our case together. We don't have our jury instructions done. So a lot of times, if we can say, folks, do you want to have the ability to discuss this? Maybe that's something we flip over to them in certain cases. But I agree with you, Judge. it just varies so much.
I think it's tough, and if you ask them and it's their first jury experience, I don't know if they feel comfortable giving that opinion, well, I'd like to discuss it, or do they simply take the conservative approach and say, well, I want to wait and hear everything first, because I don't know what's coming before I do that. The other thing that was interesting about the comments by those four persons was, this is I found remarkable, but then juries are always amazingly smart, both individually and collectively. But the other thing that they commented was, no, these lawyers, they have a plan. They have a story that they're trying to tell and unfold, and we need to let them put on that progression of evidence and tell that story so that we can hear it.
Mm-hmm.
And because there's a reason, and then it hopefully all comes together for us in terms of a picture of what the case is for us to make our determination, which I found just remarkable, an appreciation that maybe I don't need to ask questions, maybe I don't need to deliberate ahead of time, because they're prepared and they have a plan and they know the case better than I do. Let's see how it unfolds, and then we'll talk about it.
Sure.
I will agree with you that I think knowing whether it's a civil or criminal case likely makes a difference, and whether it's a really long case, a number of weeks versus just a couple of week trial, it certainly makes a difference. And I will also say, I remember that discussion last year, and I'll be a little bit of a devil's advocate. Perhaps, and I realize it was a very intense experience for the jurors in the case we're talking about. Perhaps if they had been allowed some discussion intermittently through the trial, perhaps it would not have been the coming to blows, but rather with an opportunity during the case for people to say, Mr. So-and-so didn't do very well on the stand today, did he? Well, I thought he did, and here's why. Maybe, I don't know, maybe it might have made it not such a problem at the end. Yes?
I thought it would have been helpful to say, just to recall, like ask another juror, what was his answer? Not necessarily to discuss the case or give an opinion, just to ask, because I was even reluctant to take notes, knowing that we couldn't bring them back in, to the deliberation room. And I was reluctant because we had to leave them there, and I understood that anybody could read them. And meaning anybody, the defense or the plaintiff. Is that correct?
You're talking about reading from a...
From our personal notes when we're sitting in the jury.
no, those are not shared at all.
Oh.
That's part of the original
Oh,
instruction.
okay.
Nobody gets to see them. We destroy them after the trial.
Okay, so I was thinking that somebody could look at them. I was reluctant to take notes, thinking it might, but,
And
I
you
had
can't share them,
questions.
but if you wanted to show them to another juror in the deliberation, I trust you could, if that were an issue, what your notes said. But then again, the instruction says the notes are not a verbatim transcript. You need to rely on your memories, not so much on your notes.
So it was the memory part where we went back into the deliberation room where, what was that answer, or, that
Did
would
you get an
be-
answer to your question? What was the answer? Did somebody remember?
I remember there was a couple questions in my mind, but by the time I got back in there, you're given so much information. I'm not sure I even recall, but that would have been helpful if we could ask questions to
Well,
another juror.
As we've discussed, there are a number of innovations that the Civil Jury Project is pursuing, discussing, like the one we did today, all designed to help make jury service a better experience for everyone. Yes?
I can kind of see both sides of this argument. I've been on 3 jury trials. The last one I was on, the first one, I think everybody could have discussed this and been fine. It would have been kind of helpful to pull things along. But the last one, there was really one person on the jury trial who was really problematic. And at the very end, before we went to decide, the judge excused her. I guess there was one extra, and he said, "You are going to be excused." And I think everybody was like, but if she had been there, I could see this, but it turned out it was a really opening kind of discussion.
As it turns out, that helped the discussion.
Yes.
Okay. So that's another change that's made. In the old days, juror number 13 was the alternate always. Everyone in the courtroom knew who it was, including juror number 13. So many of us now are not disclosing who the alternate is. And in fact, I am making that a
usually a joint decision between trial counsel and me of who the alternate is, and from an experience I had, it's the juror who is the least attentive, the juror who fell asleep. Whether it's one or more times, the juror who, true story, was snoring. And when I called a break for the purpose of waking that juror up, this isn't meant to demean all of you, because you all were great jurors, okay? The juror next to that person had to step over them because they still were not waking up. So there are tools now that judges have to help that process along. I call a sidebar sometimes, and the lawyers, and they say, "What do you want, Judge?" And I say, "Nothing in particular, just some of the jurors were getting a little drowsy. And so I'm giving them a chance to stand up and move around. And how's your family doing? Anything going on?" And, so we have some tricks up at the bench that we use to help the jurors as well. Yes?
Judge, doesn't the fact that there's alternate jurors on the panel, doesn't that mitigate against letting them talk during the trial? That juror is not going to be participating in the decision. If they're talking during trial, he may have a big influence on the rest of the panel as the trial's going on.
True. I sometimes will not impanel an alternate in a civil jury trial. I always use 12, whatever it is, and I figure if it's a day or 2, or even 3 sometimes, if I lose a juror, it's okay in the sense that I've still got an intact jury, but that's a good point.
Yeah, it's a very good point. I mean, as long as you're willing to give us feedback, the other innovation we're talking about is doing opening statements before jury selection.
So that you would hear the attorney's openings, and then we would have jury selection. Of course, the downside is maybe 100 people have to listen to the openings when only 12 are going to serve. The upside that we are seeing is that it's a much more meaningful jury selection because they know a lot more about what the case is about and can say, well, perhaps I'm not the best juror because my cousin had exactly the same issue or things like that. Any thoughts? Yes.
I'll just say, Jack, I think you do this too. I do require a joint statement of the case that I read to the jurors by way of introduction to the case at the outset of voir dire, and I require it to be in English. It can't be language from the indictment, it can't be legalese or Latin. It has to be, what I often tell them is, if you were explaining to your 7-year-old child at the breakfast table, what is this trial about? That's the way that you explain the language in which you use. And they often agree. Sometimes the judge has to massage the language based on objections. And I think Jack and I both try to keep it short and pretty straightforward. But it really is a narrative about who the plaintiff is and what the allegations are. And to the extent the defense wishes to put forth the defense, they may or may not, other than contesting the validity of the plaintiff's claim, that can go in there as well. But it's generally not more than 1 or 2 slides on a PowerPoint presentation at the outset. And that seems to be helpful in getting people thinking. My concern about letting the lawyers do that would be what they always do, which is they want to argue their case at opening.
Yeah.
And then, so you have to be even a little sharper about shutting them down about presentation of their case or argument at the outset. So I wonder if there's not a happy medium somehow.
Let me add to that. In addition to that joint statement, we have a questionnaire. We give them a little peek at the case. Not yet giving them the names of the parties or the witnesses, but they know whether it's an automobile accident case or a patent case or a criminal case. And then there are some questions that are designed to elicit potential prejudice that they may have. Not intentional prejudice, but they themselves, for example, were in a serious auto accident. I think between those 2 things, we get a lot of information that allows us to excuse jurors who otherwise might not be fair and impartial, plus the voir dire itself and the sidebar where they can disclose things privately. That's one reform that I'm not on board with yet.
Okay. Judge, you talked about plain language, and I want to ask the jurors about what they thought about the jury instructions. We are bringing, in the Civil Jury Project, we bring federal judges, we bring state judges, we bring jury consultants, and we bring academia in. And one of our academic studies at the last session that we had a survey of juror comprehension. And in this one study, they were given multiple choice, and 50% of the people polled thought that the term preponderance of the evidence didn't mean greater weight of the evidence or more likely to be true than not, but thought it meant to ponder the evidence slowly. So we are trying to come up with plain language instructions. Anybody, your experience, were the instructions understandable? Were they?
I use greater weight of the evidence in part because I think it is an easier phrase
Yeah.
to understand. And so I like using greater weight as the caption for what the burden of proof is.
Yeah, it shocked us when we had 50% of the people say it meant ponder the evidence slowly.
There's some trial lawyers in the room, and for those who want to stay a couple minutes more, do you have any questions or comments that you want to make? While you've got some jurors here. That's thank you all very much. For you jurors, we have, and someone will be sitting right there, and there she is, Lisa's there, with some gifts, additional gifts for you for coming today. We very much appreciate your time again and sharing your stories. And thank you all very much, and thank you, Mark, for taking the time to be with us. Have a great day.